Good morning and welcome along to The Law and You here on 4CRB. My name is Dan O'Connor from Bell Legal Group. I'm joined here by Danny Bycroft, my colleague.
Yeah, so good morning, Dan. Lovely Tuesday morning, and very good morning to all of our listeners out there, and welcome to The Law and You. So, Dan, this morning we've got a special show for everyone regarding powers of attorney.
That's right. It's a very important area, an area that I touch on a lot, being an estate planning lawyer.
Yeah, so not only are we going to talk about how people should enact their own enduring power of attorney, but we're also going to talk about what happens if you choose not to put together your own enduring power of attorney, and if you come into the unfortunate situation where a court or a tribunal is forced to make those decisions on your behalf. So just to begin with, Dan, what's the usual situation for people if they wish to give an enduring power of attorney to someone?
Well, just before I get into that, Danny, I might just put out our number if you want to call in with any legal questions. It's 5520 8888, so 5520 8888. If you're calling from below the border, of course, there's 07 at the front, the area code. You can also email through at talkback@4crb.com and we'll endeavour to get to those questions. So Danny works within the litigation and dispute resolution team, and he also has quite an amount of experience within insolvency. And I work within the wills and estates team at Bell Legal Group. So those are our areas, but we'll certainly try to help you out in any other area that might concern you. So with enduring powers of attorney, that's obviously a very important legal document. It allows you to appoint someone to make decisions on your behalf if you're in a position where you can't do that anymore. It deals with all of your affairs, financial, personal and health, and you can appoint different people to act in that role for you. But of course it's critical that you deal with this while you still have capacity. For those that don't get to the position of putting these in place, it can cause a great deal of trouble, as Danny would know, working within that sphere. But my area is ensuring that we don't get to that stage. So,
yeah, and that's correct, Dan. You know, the most important thing in this area is to make an early plan, and then to act out on that plan. So, you know, it's often one of these things that people push back. Along with having their will drafted properly. But it really is an important step that you need to think about taking. So in the future, if you come into the unfortunate situation where you no longer have capacity, it doesn't become a huge issue and a huge fight often amongst your family members and friends. So I was speaking with Dan earlier, and in Queensland, if you wish to appoint someone your attorney for both financial, health and personal matters, there is a precedent document or a standard document that has been published by the Queensland State Government. However, we as lawyers have discovered a few small clauses and issues that have been omitted from that document. And I know now, Dan, when you have people come in and wish to draft their own enduring power of attorney, there's a couple of extra clauses that you like inserting into that document.
Yeah, well, many people take a I will sort this out myself approach, which extends to wills as well, which is fine, but it is a legal document, and it's important that a lawyer does look at it to ensure that it's drafted correctly. One issue in particular that seems to crop up for basically everyone is that of conflicts. There's a number of documents that are drafted that don't attend to this, and your attorney in that position is not allowed to reap any benefit in carrying out their role. And when it comes to who you appoint, the most logical person and the usual appointment is actually your spouse, which when we think about it, there would be quite significant scope for conflicts arising, given that you share assets, you share a home, you share expenses. So we need to ensure that that's covered off in the document so that you're not painting yourself in a corner when it comes to how you can enact that document when someone loses capacity.
And just for for those listeners at home, what are some examples of conflicts that you see where one spouse has appointed another spouse as their financial attorney, for example?
Yeah, well, a very common one is the situation where an elderly couple have got to the stage where one of them needs to go into aged care and the other wishes to stay at home, but the property needs to be sold and applied towards an accommodation bond for the person moving into aged care, and then potentially downsizing to a smaller unit for the other spouse. The issue that presents is that if you don't have provisions for conflicts in that situation, the unit being purchased for the spouse who's not going into aged care would have to have equal value to the amount that's going into that aged care bond, because they can't reap a further benefit beyond that 50% ownership or whatever it is on the title. So we always provide provision for ensuring that they can have their adequate accommodation and needs.
Okay, and also, Dan, just before we go to this first caller, I understand that there's also one other very important extra provision that you like to put into enduring power of attorney documents, and that's something that allows the attorney to deal with other roles that the adult might have. For example, their role as a director of a company, as a shareholder, as a trustee.
That's right, and that's something that's not often covered off, but we'll get to that in a second. We might just go through to our first caller.
So, John, good morning.
Yes, my name is John. I live in New South Wales, and we've had a will done and also an enduring power of attorney.
Okay.
I had a stay in John Flynn Hospital late last year, and one of the things that they asked for, did we have an advanced health directive? Now, I understand that that's a Queensland document, but I don't know if there's one in New South Wales. Could you tell me if that's the case? And if we've got an enduring power of attorney, is that enough, or should we get an advanced health directive done as well?
Yes, well, it is a state-by-state jurisdiction. So in Queensland, as Danny mentioned, we have the one form to deal with everything, and then alongside that we have the Advanced Health Directive, which is obviously to deal with health matters, but it's just more of a guideline or your wishes to your attorney as to what you would like to have in that instance. In New South Wales, I am not actually entirely sure about whether they have an analogous document to an Advanced Health Directive. I would need to find out, because most clients that we have obviously come from Queensland, and although we've prepared many enduring guardians and enduring powers of attorney for clients in New South Wales, I haven't come across the Advanced Health Directive option there, so I'm not entirely sure. I do know that in the document itself you can provide directions and wishes to your health attorneys, so that may be the way they deal with it down there, but I would have to revert to you on that.
Yeah, John, what we'd like to do is if you want to call back for CRB, or otherwise you can email your details through to that talkback@4crb.com email address. Dan or I would be more than happy to give you a call after we get off the air today, and we can look at that matter a little bit more.
Do you want me to leave my phone number with the lady on the... or ring back?
That'd be great, John, and we'd be more than happy. If you can leave your phone number with her, that's fine.
Yeah, and I'll get back to you later today.
I'll leave my phone number then.
Okay, excellent.
Thank you.
Thanks, John.
Okay, bye.
So Dan, we were just speaking about now that people's financial affairs are becoming more and more complicated, it's becoming increasingly important for them to include a clause in their enduring power of attorney document which allows the attorney to deal with things like shares, their power as an appointer or as a trustee, their role as a director of a company. Have you seen any examples where the failure to include that clause can lead to people coming unstuck?
Well, it's an unsettled position at law as to the power of an attorney to step into those roles automatically. But beyond the power of attorney, and we always include this out of a matter of caution, you do actually need to look at the underlying constituent documents for the trust or the company, including the constitution or the trust deed, because that really is what governs the power for someone to come in at that point in time. So it's really a two-pronged approach, and looking at either in isolation isn't going to satisfy that situation. So beyond those issues, there's also that of your superannuation. And these days your super is your largest asset, if not maybe your second largest beyond the family home. So that's an asset that falls outside of your estate, but it's also an asset that you want to ensure is providing adequately for your family. And when it comes to your super, that's governed usually by your binding death benefit nomination as to who's going to receive the benefit of that if you pass away. But the issue that comes alongside that is that usually these nominations you have will lapse after 3 years. So even though you've provided for a beneficiary, if something happens to you in the interim and you lose capacity, you find yourself in a position where that nomination will lapse. And it's your attorney's responsibility to step up and reinstate that for you. But they can only do that if it's not going to be a conflict of interest. And as I mentioned before, normally it is a family member who's going to be coming into that role for you, and they're usually the one who's going to be reaping the benefit of that. So unless we've adequately covered that off, it's a situation where they may not be able to ensure that that's going to be covered off in your sort of affairs and your estate plan. There has been some changes in the law in this area, and it is catching up, but without that clause in the enduring power of attorney document, you may not be able to put that in place.
Yeah, so I think it comes down to it's a very complicated area of law, and although similar to your will or other documents, yes, of course, you can go and get a standard document from the post office, but in this day and age where people's affairs are becoming more and more complicated, it is really important to take professional advice. So we've got another caller on the line. We'll go to Margaret. Good morning, Margaret.
Oh, good morning, John. I have a quick question for you.
Okay.
Friends of mine were married. The marriage lasted for 2.5 years. She decided she wanted out. Now, after a period of, I think it was another almost 2 years, she filed for divorce. The divorce went through, in July in the courts in Brisbane. Now, do the courts will they notify my friend, or does he have to contact the courts? Because he has never had any paperwork from them. He signed the paperwork to go ahead with the divorce. It was a mutual thing. And the divorce went through on a particular date in July. And so do the courts send out paperwork, or does he have to apply for them?
My understanding, Margaret, is that if your friend has provided what's called an address for service with the courts,
yes.
once the courts make orders granting that divorce and ordering that the marriage is a nullity, then they should send sealed copies, so they're copies of the orders that are stamped by the court to your friend's address for service he's given with the court. Now,
yes.
Often
has not received anything as yet.
And when did you believe that the orders may have been granted?
The court case went to court on the 9th. I believe she didn't appear. He didn't, definitely.
Yeah.
So we were just assuming that maybe the courts would send a notification that divorce had been granted and you had X amount of time to wait.
Yes.
I mean, there's no hurry for this, but we were just wondering if he gets notified or if he has to contact the courts himself.
Yes.
He didn't apply for the divorce, she did.
Yeah, so he should get notified if he's provided that notice of address for service. But I would say it can take up to 60 days for the courts because it takes a long time to filter its way through the system. If you'd like to leave your phone number with the switch here, when we get off the air, I'd be happy to do a quick search for you when we get back to the office, and we can often find the outcome of those matters before he gets the formal notification to his letterbox.
Oh, okay, John. Thank you very much.
No problem, Margaret. Okay, so we're going to move to a quick break now. And after that, Dan and I are going to come back and speak about a few examples of certain cases that we have worked on when power of attorney documents have not been put in place, or when these issues go wrong. And also we're going to be taking up some more of your calls. So we'll be back shortly.
What are you doing for lunch today? Why don't you shout yourself a good old-fashioned pub meal at a good old-fashioned price and head over to the Runaway Bay Tavern? They've got plates to share, salads, pizza, steaks, burgers and kids' meals. Plus, to top it off, at the Runaway Bay Tavern, they have specials for seniors starting from a good old-fashioned $10. Runaway Bay Tavern. Good old-fashioned pub meals at good old-fashioned prices. Located at the Runaway Bay Shopping Centre.
Childbirth, menopause and ageing can create changes in a woman, making intimacy painful or causing conditions like itching, burning and dryness. There is now a clinically and evidence-proven breakthrough in treatment of these and other related conditions. Mona Lisa Touch is a minimally invasive therapy that in most cases can help you get back to normal in no time. Contact the Mona Lisa Touch female consultants now at Cornerstone Medical Centre, Beryl Street, Tweed Heads on 5536 5068, a sponsor.
Welcome back to The Law and You. This is Dan O'Connor and Danny Bycroft from Bell Legal Group. We're taking your calls this morning with any legal queries you might have. The number is 5520 8888, 5520 8888. So before the break, Danny and I were talking about enduring powers of attorney and what can go wrong when they're not drafted properly, or if they're not put in place at all before someone loses capacity. So Danny, what have you experienced in this area when it comes to those applications to QCAT?
Yeah, so the starting point here, Dan, is when a enduring power of attorney hasn't been put in place, or of course if there is some sort of dispute over the validity of an enduring power of attorney, or a person that has been appointed an attorney or an administrator or guardian. It's up to the parties to apply to the Queensland Civil and Administrative Tribunal. They have a specialist division at the tribunal there, which is just known as the Guardianship and Administration Division. And basically, if you don't have your affairs in order, then the decision is left with the tribunal member, who will appoint either a guardian or an administrator on your behalf. Now, it can be a very emotional, a very draining and time-consuming process, having to have these matters aired in a public tribunal, and also it can lead to a very difficult time for your family, because it often brings up some old family issues that aren't necessarily ones that you want to know more about. So just before we get into a couple of case examples, the switchboard's lighting up here, and we've got Ivan on the line. Good morning, Ivan.
Oh, good morning. I'm just listening to your program, and I've got an enduring power of attorney, and I heard you say something about it lapses after 3 years.
So it's not the enduring power of attorney that lapses. An enduring power of attorney, much like a will actually remain in place forever until you decide to change it, pending other circumstances such as marriage and divorce. No, but it was actually your binding death benefit nomination with respect to your superannuation that actually might lapse after 3 years. So if you don't have super, then it's nothing to worry about. But if you do, and it's with like a retail fund or an industry fund, those nominations, depending on the fund, some allow non-lapsing nominations, will routinely lapse after 3 years. Okay,
that's all right. It just sounded to me like it was the enduring power of attorney, which bothered me a bit.
No,
okay.
that might cause a few problems if that was the case.
It's good that you checked off on that one, Ivan.
Yeah, keeping us on our toes.
Okay.
Thanks, Ivan.
Thank you very much.
Okay, and we'll now go to Jenny on line 2. Good morning, Jenny.
Good morning. Look, my husband and I are pensioners. I just wondered, how much does it cost to make a will?
Well, it very much depends on how complex your will is. if you're in a simple situation where you're pensioners, you don't have any family trusts, you don't have any companies, you aren't trying to cut out children, etc., and the wills themselves are quite straightforward. You're looking at maybe a few $100s for a simple one. The public trustee do put in place wills. I believe they still do it at no cost as an alternative. But generally,
but don't the public trustees then take their percentage out when you die? Or?
Yeah, so the public trustee, I believe, and I'm not entirely sure on this, but I think that if they are appointed as your executor, that is the situation where you don't have to pay for the will. Yeah. And in that role as executor, that's right, they do charge fees to act in that role for you.
Right.
As you probably know, Jenny, Dan and I are from Bell Legal Group, and the cost of having a professional solicitor not only draft your will, but also retain a copy of your will in a safe custody room really is invaluable. Yeah. So if you have your will drafted by a professional law firm, they'll retain a copy of that document, and daily they do searches of the newspapers to see if there have been any deaths of people whose will they retain on safe custody, and if for some reason the other copies of your will have been misplaced, then the law firm will go ahead and contact your next of kin and your family and advise them that they have a copy of the will on file.
Right. But as a lawyer, like if we made a will with you people and you were the executors of our will, there'd be an extra cost for that. Is that right?
Not in the preparation of the will. No, we act as executors for lots of clients. We normally encourage them to appoint family members if they can, because it does save money to the clients. But yes, we do act as executors for lots of clients. In the preparation of the will itself, it's the same charge whether or not we are acting in that role for them.
Right. So can you just give me a rough idea for a husband and wife, what it would cost us?
I think our simple wills for a husband and wife, it's $500 plus GST. That's what you're looking at.
Right.
Thereabouts.
Okay. Righto. Okay.
Thanks for the call.
Hi.
So Dan, we were speaking about what can go wrong if people don't have their enduring power of attorney or other plans in place. And I was acting recently on an interesting matter where a lady had been placed into a nursing home by her kids, and under their power of attorney, and a friend of hers actually came and kidnapped her out of the nursing home, and then took her to an unscrupulous solicitor who duly allowed her to draft a new enduring power of attorney, appointing the kidnapper as her new attorney. And that matter ended up in QCAT, which became a huge family dispute. So we do see these sort of situations, and it is becoming an area of law where there are more and more disputes. So unfortunately, everyone, we're beginning to run out of time here this morning. So if there's any more quick callers that can come through, your time is starting to dwindle. Otherwise, you can feel free to email us here at 4CRB. That email address is talkback, TALKBACK, at 4crb.com. You can email through any questions to that email address, and we will make sure that the radio station here passes those on to Dan and I, and we will happily answer those for you sometime today. So, from myself, Daniel Bycroft, thank you very much for having us this morning, and I'll now pass it over to Dan O'Connor to sign off.
All right, ladies and gentlemen, thanks for joining us this morning. It's been The Law and You. I'm Dan O'Connor from Bell Legal Group with my colleague Danny Bycroft, and you have a good day.